All right, I think we can get started here. Okay. Good morning, everyone, and welcome to Jeff Tenenbaum's follow-up Q&A session. My name is Sarah Cragness, and I'm the Association's North Education and Project Manager. And I have the honor of introducing Jeff again. Before we get started, I just wanted to remind everyone that if you think of a question during this session, please put it in the chat box, and I'll be moderating it and making sure that those questions get answered before the end of the session. For those of you who may miss Jeff Tenenbaum's session at the Meeting Planner Symposium, Jeff is one of the nation's leading nonprofit attorneys and is also an accomplished author, lecturer, and commentator on nonprofit legal matters. As managing partner of the Washington, D.C. based Tenenbaum Law Group, Jeff counsels his clients on the broad array of legal issues affecting trade and professional associations, charities, and other nonprofits. For 19 years, Jeff practiced law at the Benet law firm and chaired its nonprofit practice for most of that time. Among numerous other honors and awards, Jeff was the 2006 recipient of the American Bar Association's Outstanding Nonprofit Lawyers of the Year award, and is one of only 5 lawyers in the prestigious U.S. Legal 500's for Not-for-Profit Hall of Fame. Jeff is the author of ASAE's published book, Association Tax Compliance Guide, and currently serves as chair of the American Bar Association Trade and Professional Association Subcommittee and on the ASAE Legal Advisory Council and Public Policy Committee. So everyone, please welcome Jeff. Hi, Jeff. How are you doing?
Good morning, Sarah. Thank you. Good morning, everyone.
So we'll start off here. I know this is going to be kind of a more casual conversation, and so we're going to be doing just lots of Q&A, and we're scheduled for an hour, so we'll just kick it off with the first question. Is there anything we can do as an association to protect us from liability if someone voluntarily attends an event and gets COVID?
Great question. First off, let me say that most of the topics that you sent me some questions that folks had submitted in advance, and I think every one of those questions, virtually everyone, is covered by a series of articles that I've written over the last few months, kind of since the pandemic occurred. I've been trying to write articles on all of the leading issues, legal issues that associations are facing during this pandemic. And so while today we're going to cover all of those questions, we're really only going to be able to scratch the surface. So I think, Sarah, you might have already circulated my most recent article to everyone, but I'll make sure you have links to all of them so you can circulate them, because I want to make sure that everyone has the benefit of kind of the more fulsome discussion of these issues, so you can kind of drill down, because frankly, most of them are pretty complicated. There's no simple silver bullet answer. I mean, every one of these I could probably spend 20 minutes talking about. I'm not going to bore you and do that today. But I mean, to me, they're very interesting issues from a legal perspective. They're very challenging. They have very real and scary consequences, significant financial consequences. And so it's really important that you understand kind of the nuances in this area, and I'll try to do that today. So, this first question about in-person events. I mean, look, this started, really, it started prior to March, but really, for all intents and purposes, associations really started to focus on this in a very significant way in early March. And over the last few months, and my colleague and I have worked with over probably 250 different associations so far on all of these different issues. So we've seen it from every angle. These are mainly national associations across the country that hold meetings and conferences in venues all across the country and internationally as well. A lot of them were planning on having in-person meetings even as this fall, and especially October, November. This was 2 months ago when you're doing our game planning. They wanted to cancel the meetings that were coming up in the summer, but some of them they were rescheduling and postponing to the fall, with everyone thinking that we were going to be back to in-person meetings. Well, as we've seen from the last few weeks, no one's really thinking that anymore. No one's really, at least I'm not aware of many. I've heard of a few, none of my clients, but I've heard of a few that are planning and contemplating having in-person gatherings later this year. Most have completely taken that off the table. And so, for now, the question about risk of contracting the virus at an in-person meeting is probably a moot point if you're not having in-person meetings. But there are some. Reason I was a little bit late coming on, I was on the phone with a client that's contemplating having its board meeting in October in New Orleans in person. I mean, frankly, I don't think it's going to happen, but they're still leaving that on the table. And if you were contemplating any in-person meetings, something the size of a board meeting is more likely than a large conference. In part because most states and cities that are banning large gatherings, they ban based on the number of people, and it's not going to be until the final phase of most states and cities reopenings that they will allow larger gatherings of like over 100 people, which is most conferences and whatnot. So legally, you're not even going to be able to contemplate that. Frankly, most states and cities are saying that until there's a widely available and administered vaccine, that larger in-person gatherings are not going to be allowed. And we'll talk about, I'm sure, the effect of that on meeting contracts and cancellations and liability. All of this being said, as we look forward to 2021, and hopefully we get multiple vaccines that are fairly widely administered and are effective, and then people start to really focus again on what we all love, in-person gatherings. And they start looking to next year. But the virus is still going to be around. No one has a crystal ball, but we can pretty much say for sure it's not going to go away overnight. It's going to be a risk. It's going to be a risk that people are scared about. You're going to have reduced attendance, even at meetings, especially the early part of next year, maybe all of next year. You're still going to have people who are scared to travel, to go to large gatherings. That's going to have an effect on your attrition penalties and everything else. We'll talk about that in a bit. But in terms of the in-person meetings, all of that to lead up to say, don't even worry about it right now. But when you get to that point and you're contemplating it, the key question from a liability perspective is, was the association negligent in how it put on its meeting? Was it negligent in not protecting the health and safety of its attendees? It's a pretty simple question. It's a very complicated answer. Negligence is a form of what's called tort liability. And this is what all lawyers study in first year of law school. It's called torts class. And when you study torts, you learn about the elements of a claim of negligence. And the first, there's like 5 elements to a negligence claim. One of the elements is, do you have a duty to certain people? Here the question would be, do you have a duty to protect the health and safety of attendees at your conference? I think without question, the answer is yes. Although I would certainly say that the venue where you're holding the event, like say it's a hotel, also has a shared duty. And the duties are going to be a little bit different. It's a really interesting legal question, is kind of what duties fall on the association, what fall on the hotel. I was working with a client earlier this morning where they're going back and forth with a hotel and a contract about who's going to have responsibility for doing what things. And they're going back and forth. The hotel is insisting that every attendee sign a liability waiver before coming into their hotel. But they're putting the duty on the association to gather up all of those signed waivers and provide them to the hotel. And we're going back and forth on, is the hotel going to be doing temperature checks of people coming in, or are they going to try to push that obligation over to the association staff? All of these things are things that will have to be worked out contractually between the parties. But assuming there's a duty, then the next question is, what is the standard of care? What is the standard of care that the association has to meet in order to avoid being negligent? Okay. And that's a really difficult question, because there is no one place you look to say, oh, that's the standard of care. That's what it is. That's what we have to follow. In most cases, as in here, it comes from lots of different places. It gets informed by a lot of different things. What are we talking about? We're talking about CDC guidance for sure. CDC has already put out some very detailed guidance. Surprising. It's not mandatory, but it's guidance and it's relevant. And it would definitely be factored into what is the legal standard of care that you have to meet in order to avoid civil liability for negligence. you would have to, I think you need to abide by all of those CDC guidelines. And frankly, of all the CDC guidelines, and one of my articles about this has a link to it, so you can see it. I'd say 2/3 of the items in there really fall on the hotel, things that they have to do, a lot of cleaning and all sorts of other things like that. Some of them are going to fall on the association, the social distancing and the enforcing mask wearing and other things like that. But that's one place that the standard of care gets informed by. We are already seeing states and cities, state and local governments imposing requirements on things like reopening of restaurants and businesses. Just yesterday, Commonwealth of Virginia announced mandatory guidelines for the reopening of offices in Virginia, things that you have to follow. And these things are binding and mandatory. And I suspect that as we start to get into large gatherings happening, we will see mandatory state and local guidance there as well on things that you have to do. So, of course, that'll be part of the standard of care. Bottom line is you have to abide by those things as much as you can if you want to avoid liability. If someone alleges that they contracted the virus at your event, and that you are responsible for it. Now, causation is always going to be difficult to prove with this virus. Did they truly prove that they got it at the event? My thinking is that will generally only be able to be proven when you have a cluster of people that all contracted it at the same time, and the contact tracing suggests that they all got it at the same place. And then that's very possible. And we saw that happen early on in the pandemic. Several large, even some association gatherings, a bunch of people contracted the virus. So if you do all of those things, and if you impose on the hotel or the meeting venue, and there might be multiple people, there might be meeting vendors and others that are involved. But if you impose on the other parties their obligation to do all of these things, even just putting that into a contract shows that you, the association, are not being negligent in how you're holding the meeting. Therefore, it's going to be much more difficult for someone to hold you liable. And then I saw a question pop up in the chat, and I'll answer it now because it's relevant to this. A liability waiver issue, okay? That is another kind of tool in the toolbox of things that you can use to help mitigate your liability risk for in-person meetings. Is it going to save you and save the hotel from all liability? Absolutely not. It just doesn't work that way. Liability waivers get thrown out by the courts when they get challenged all of the time for different reasons. Unequal bargaining power between the parties. If someone can show that you were grossly negligent, the waiver is not going to have any force and effect. And even the waiver itself is going to be predicated, kind of built in, even if it's not written in there. There's going to be some built-in assumptions that yes, the attendee is going to supposedly on paper release you from liability, but that presumes that you, the association, and you, the hotel, are taking certain basic steps to keep protect their health and safety. If it can be shown that you failed to do those things, there is a good chance that the liability waiver gets thrown out, because a court might say, well, the person signed it or agreed to it, however, click and accept, whatever the mechanism is, but it was predicated on a basic presumption that you would be following CDC guidelines and things like that. And if you did not, again, it might easily get tossed out by a court. So that's my thinking on liability waivers. They can't hurt. I think they are probably going to become the new normal. I think you're going to, just like, we all go onto different websites and things and we click and accept that we agree to the ability to use cookies to track us and all that other stuff. I think it's going to become like that. People won't even think twice about it. Doesn't mean you should not do it. I think you should, unless you get big resistance from your folks. There are ways to write them that might be a little bit less offensive. And then one final point on this. If you're going to have a liability waiver, my suggestion is, A, to help further protect your association from liability risk, but also B, to help protect the health and safety of your attendees. Also put in that document what you expect your attendees to do, right? If you are going to enforce mask wearing in all public areas of the conference, like except when you're in your own hotel room, or except when you're at your own table with your own, whoever you might live with, if that's even a situation. Basically, anytime you're in a public area that you're going to expect people to wear a mask, put that into the liability waiver, that they agree to do this. It helps to, again, another step to help protect you from liability risk, but it also sets an expectation of this is what we want you to do. I'm not suggesting you have to do that. I mean, a lot of other people are. I'm not going to weigh in on that very sensitive issue these days. But if that is your expectation, put it in the liability waiver so that people have an affirmative obligation to do that. All right, that was a very long answer to a one sentence question, but I
I
think I
think
tapped.
so. No, I think that's wonderful. And I think you covered a lot in there as well, and maybe have even sparked some more conversation and other questions. So, like I said before, if you have any questions, please keep putting them in the chat box. I'd love to bring them into this conversation. Moving into more contracts and stuff like that, do you have any examples of COVID clauses that we should be putting in contracts when we hire speakers? So, like basically cancellation policies, postponing, that sort of thing. Is there COVID specific verbiage that needs to be used at this point?
So, short answer is yes, there are some. But the first thing we got to do is distinguish between contracts that already exist, they've already been executed, meaning signed by the parties. Say you have a contract with a paid speaker for your scheduled annual meeting that's coming up in September or October. In-person meeting, looking like you're going to need to cancel to make it virtual. Say, this is obviously a very real situation that I've been counseling many associations about over the last few months. And so my colleague and I will look at the contract and see what it says in there. First thing I hope it says, I always look for, and this is something that we've always kind of written into contracts in the past, but they're not always in there, especially in speaker contracts. And that's what's called a force majeure provision. You probably all heard that term. And we've largely been focusing on it, and I will focus on it today in connection with the ability of your association to cancel, say, a contract with a hotel or convention center and escape any cancellation penalties and liability under that contract. But it also applies in other contracts, like a speaker contract. So, if it's a contract for a paid speaker, if it has a force majeure clause, and if that clause would enable you to cancel the contract without penalty, that's an ideal situation, because then you can cancel the contract, not worry about any penalty. And then if you decide you want to have that speaker, participate in your virtual meeting, you can. If you decide you don't, because you're going to make far less money off this conference anyway, so you're going to be able to have far less paid speakers, or even no paid speakers. Ideally, maybe you're just going purely with your member speakers, volunteers. At least you have that option. Whereas if the contract does not have a force majeure clause, it becomes a lot more. And if it, either it has cancellation penalties, or even if it didn't have cancellation penalties, if you were deemed to have breached the contract by not paying the speaker, the penalty would be whatever the speaker fee would be. And he or she would probably have a pretty strong claim against your association. So that's the first thing you want to look for. Is there a force majeure clause? Another thing you want to look at is, how does the contract define, is it clear that it's an in-person speaking presentation, or is it unclear in that it could also apply to a virtual meeting, right? I've seen some that are written very vaguely that, a speaker can claim, okay, I get it, you switched from in-person to virtual, but you're still obligated to have me. There's nothing in the contract that said this only applied for an in-person meeting. That sort of thing you want to make clear one way or another. There's no right or wrong. Maybe you want to write it that it's one way or another, but my guess is you probably want to write it that it's only in person, and that you have the right to cancel if you cancel that. If I was writing a provision now, I'd have a good force majeure clause in there that enables you to get out, but I'd also have a clause that says, like, say you're planning for a meeting mid next year or something, you're assuming it's going to be in person. I would put a clause that expressly says, if you decide not to have the in-person meeting, then the contract is null and void, and you don't have to pay them out. Contracts are two ways, right? The speaker might push back and push back hard against that. Who knows? But that's what I would propose, so that you have the ability to get out of that. While this isn't really a COVID-related clause, it's something that's come up in the discussion of the pandemic, and that is copyright issues and release issues. First, let me just explain, and I've done, even in the last few months, I've done webinars just on hour and a half on copyright and trademark issues alone. So this is a really 2-minute overview of a really important but nuanced issue. And that is, there's a difference between copyright law and the right of privacy. A lot of people get this confused, but it comes up all the time in the association meeting context. And in-person meetings, virtual, doesn't matter. These issues come up all the time. Copyright is the right that, say, in this case, the speaker, it also applies like to an author, writing articles, the speaker's words and the speaker's PowerPoint presentation and the speaker's handouts. These are all things, these are their original works that they created. They are the copyright owner of those works. Or if they're employed by someone else and it's within the scope of employment, then their employer actually owns them. But regardless, either they or their employers, they are the copyright owners of those works. And so if they are going to give you, the association, permission to use those works, whether it's to put it up on some site after the conference is over, to keep it on your members only part of your site for people to access later, to create compilations, derivative works, whatever else you might want to do. And associations take that content all of the time and repurpose it for different purposes. You want to make sure you have a broad copyright license, which means permission to use. If the speaker is saying, I give you permission to use this stuff forever in any way that you want, and you don't have to pay me, get more permissions from me, anything else. There's other things you want to include there as well, like a representation from the speaker that it doesn't infringe anyone else's copyright, that it doesn't defame anyone, that it doesn't violate antitrust laws, it doesn't invade anyone's privacy, etc. Some other things you want to put in there. But it's really important that you get that broad, perpetual, irrevocable copyright license to use their works. Again, if it's online or virtual, it doesn't matter, same thing. Separate and apart from that is the right of privacy. And the right of privacy comes into play when you want to record someone. And with in-person, this is where there is a difference, because most associations in the past have not recorded a lot of in-person sessions, at least sometimes like the general sessions, but most of the rest, they haven't recorded them because it's just prohibitively expensive to have these AV companies come in and do it. But with virtual meetings, completely different story. Like I see the button at the top that today's session is being recorded, right? And you did ask my permission to do that in advance. You press a button on Zoom and boom, you have a recording and it costs you nothing, or virtually nothing, depending on your whatever kind of license you have from Zoom. But basically it costs you nothing. And then you have great content that you can repurpose for other purposes, right? You can take this recording and put it on your site. So, like today's program, webinar is a good example. I'm giving you, there's no PowerPoint, but I'm giving you a bunch of articles and I'm giving you permission. You did not give me a copyright form to sign or agree to, Sarah, but you should, and I can give you one to use if you want, that I will then sign. But you should, for all your speakers, get that kind of copyright license that I was giving you. And then as part of that same form, it should also have a release. A release meaning I'm giving you permission to record me and then to use that recording in any way that you want. That has nothing to do with copyright. It has to do with the right of privacy. But it's very important to do so that you have the right. And you bake it all into the same form. And I actually have a simple one-page form for speakers that I'll send to you that you can give. Someone just asked, yes, I will give it to Sarah. Making a note. And we use this all the time. In fact, the form that ASAE uses is one that the basic form I wrote for them years ago, and it's still the basic form that they use and I use today. And I will send that to you for you guys to utilize. But it's really important that you do that to protect your rights, to make sure you never have a claim later from someone else that you were doing something without their permission. So again, long answer, but these are important issues. They're really not COVID related, but the recording part comes into play more these days.
Right, absolutely. With everyone going virtual, it's so easy to hit that record button, and sometimes that could probably get missed to ask, or like you said, give that waiver. Or yeah, that's really good information. Thank you. And then another question we have is, do you recommend involving legal counsel in initial conversations with a venue?
Generally speaking, no. I get that question all the time. And we've worked with literally hundreds and hundreds of various cancellations, because now dealing with multiple conferences for the same associations. Been down this path so many times in the last few months, and we've had great success. Just heard 2 more this morning where the hotels agreed to accepted force majeure cancellation and expressly said they're not pursuing any penalties. I'd say we so far had probably a 95% success track record. And part of it, there's a lot of different elements that go into that, and I'm not taking credit for all of the successful force majeure terminations that my clients have been able to effectuate. But there's a lot of different factors. And one of the factors is that question: what is our role as legal counsel, and how do we get involved or not get involved? And one of the things that, I don't know, I just made a decision early on that my gut told me it was not going to be helpful or effective. And this is informed by a lot of past experience as well, to have the lawyers on the calls, phone calls, video calls, whatever, with, say, the hotel staff about this stuff. Because what happens is, as soon as the hotel realizes legal counsel for the association is going to be on the call, then they have to get their legal counsel involved. And it completely changes the dynamic of the discussions. And it's generally not particularly helpful or productive. They tend to get their backs up more. It just doesn't go well. I have gotten involved in some of these, but in every case, it's been after the fact, after we, the association provided force majeure termination notice, canceled the meeting, hotel disagreed, hit them with a big bill for cancellation penalties, and then we get their lawyers are involved, I'm involved, and then there have been some cases, a few, where I've gotten involved in negotiating directly with their lawyers over it. But beyond, in the vast majority of cases, I don't recommend that. What I do recommend, though, and I'm not just saying this from a self-serving perspective because I'm an attorney, you need to work with your attorney on this, some attorney. It's absolutely critical. There's so much that goes into doing this. It's really an art, not a science. And every single one of these cases is different. And every day, I think I have two calls scheduled later today with clients. Sometimes it's with the staff, sometimes it's with the executive committees, other folks, to go through the analysis, right, for every single one of these cancellations. We have kind of a system in place now. We hear from a client, they send us the contract or contracts. We do this kind of 2-page summary analysis of the situation, and then we get on the phone with a video call and we talk it through. And then sometimes we have that conversation again a month from now, and then another month from now, because the circumstances change all of the time. And I will get into that whole analysis as soon as we get to one of those other questions. But bottom line, for this question that you asked, consult with your legal counsel every step of the way leading up to it. Have your legal counsel either write or review the termination notice, all the other things, but don't have them in the direct communications with the hotel. The one thing I have recommended more recently is on the force majeure termination notice. If you're going to go that route, I do recommend copying your legal counsel on that letter or that email. It lets them know, the hotel, and the hotels always give those letters to their attorneys. It lets them know that you had legal counsel involved. It just gives it a little more credibility if you copy your lawyer on the letter.
Sure. That's great. And then we have another question that came in, and it says, we have 2 live events coming up, one in January and one in February. We've already cut our expected attendance in half to comply with the maximum allowed capacities, but still need more space at the facility than what was originally contracted. Is it normal for the facilities to charge us for the extra space just to hold half of the originally expected attendees?
This is a great question, and it's a very real-life question that's coming up all of the time recently. And the short answer is I don't have an answer for you yet. I know the position that we are taking on behalf of our clients is that, hey, look, we contracted for what would be enough space, let's just say 100 people. I'm just picking raw numbers, right? We contracted for space for 100 people. Now that the state or local government and or CDC is mandating and or providing guidance on appropriate social distancing, that's not our fault. You still have an obligation to provide us within those guidelines, those social distancing guidelines, enough space for our 100 people. And if that means double the amount of ballroom space and meeting room, breakout rooms and things like that in order to be able to accommodate that social distancing, that's on you. That's not on us. You shouldn't be able to charge us for it. That's my position. We've yet to really see this, I don't want to say litigated. These things might get litigated down the road, but even just battled out, because there have been so few in-person meetings. Where we're seeing it battled out right now is in the contracts, right? And you're right. Whoever asked that question, I have seen not a lot. And most of the hotels have actually said, that's fine, we're happy to provide it, because right now, no one's holding in-person conferences and no one wants to hold in-person conferences. So they have all the space in the world. Again, this is assuming it's a bigger property that has more space than what you contracted for. There are some smaller venues that just don't have the space. But assuming they have the space, in your question, clearly they do have the space and they want to charge you for it. The position that I articulated a few minutes ago is a position that I would take if I were you. But they might push back and say, look, you contracted for, I don't know, just picking raw numbers, 100 square feet of meeting space. And it's not our fault as a hotel talking. It's not our fault that, the social distancing guidelines say that you now need 200 square feet of meeting space. You only contracted for 100 square feet. So if you want, we'll give you the 100 square feet and you just only allow half as many people to come. Or if you want more space, you're going to have to pay for it. It's an argument, and it's not a horrible argument on their front. I don't know the answer to this. I think like everything else, it's going to have to be negotiated. Right now, if they have the space and there's no opportunity cost, not like someone else is going to take it, no skin off of their back. It doesn't really cost them more to give you the extra space. But when we come to a point, hopefully, where there are other groups that are willing to pay for that space, they're going to start pushing back hard and say, we're not going to give you this extra space unless you pay us more for it. And I don't know, because part of it is dependent on how you interpret the contract, right? Are you contracting for the amount of space specifically, like that 100 square feet, or are you contracting for whatever space is legally needed to accommodate 100 people? And most contracts aren't written that specifically where you could derive that answer. So it's a great question, and it's one of those things where you have to see how this plays out, and you're going to have to negotiate it like everything else.
Sure. Another attendee said, we have an event in February and the hotel says it's too early to cancel, but won't give us a timeline for when they would be making these decisions. What would you recommend?
Did you say November?
February.
February. Yeah. So, first off, if you ask the hotel when they are going to cancel or tell you you can't have the meeting, good luck getting an answer before 30 days out. I mean, in the past few months, it's been a bit different, especially early on. As we start to get, hopefully, through the worst of the virus and we make a turn into next year, you're going to see less and less willingness of any hotels to say that, right? Granted, right now, a number of them are closed. It's a bit of an easier question, but as we get into, say, February next year, and hopefully people are having in-person meetings, they're probably never going to say, we're canceling on you. You can't rely on them. I never rely on the hotels to do that. If they do, that's a bonus. That's great. But that's not how it normally plays out. Normally, the association, need to take the bull by the horns, and you want to be in the driver's seat. And I guess let's get into the basic analysis here of kind of force majeure termination. So this is what this is probably my 30th time talking about this on a webinar just in the last few months alone, maybe even more than that. And like I said, been down this path hundreds of times with clients on this basic analysis. And here's basically what this is all about. So you have a contract that says you're obligated to have your meeting, in this case in February, X number of people on these dates at this venue. And it says, it's got your attrition clauses in there. It says, here's our guaranteed minimums for sleeping rooms, if it's a sleeping room event, and food and beverage minimums. And if you fail to meet these minimums, here's your attrition penalties that you'll pay. And then separate and apart from that, it's got a cancellation clause that says, if you cancel, and usually the cancellation penalties will increase as you get closer to the event dates. If you cancel on these dates, here's the cancellation penalties that you will have to pay. But then most contracts also have what's called a force majeure clause that says if, and these clauses generally have two parts to them. The first part is there a triggering force majeure event, like an act of God, an act of war, or a pandemic, or things like that. Or usually what it says is any other event beyond the control of the parties, unforeseen event beyond the control of the parties. That's the first part, right? And clearly the pandemic is an unforeseen event beyond the control of the parties. The only time you'd have trouble is if the clause is written so narrowly that it only has like 6 events listed and it doesn't have one of those catch-all phrases. But then the second part of the clause is where really all the action is all about, and that is what effect does that triggering event have on either party's ability to perform under the contract. And what most force majeure clauses have is the words impossible or illegal, meaning does that triggering event make it impossible or illegal for you to hold your conference? That's the basic analysis. Now, it's definitely less than 15% of all of the ones that we've seen, maybe even less than 10%. But some of them, and this is how I like to write them, will have additional words like inadvisable or commercially impractical. Commercially impractical being the most common, after illegal and impossible. What you want ideally is to have the words commercially impractical in there. It's a looser, easier standard for you to meet, to show that it is commercially impractical for you to hold the meeting as opposed to just being illegal or impossible, which is a very high standard. But presuming you have the illegal or impossible standard, then the question is, what makes it illegal or impossible in light of the pandemic for you to hold the meeting? And what the hotels and convention centers are saying is the only thing that makes it illegal or impossible is a governmental ban on having gatherings of your size on those dates in that city or state. That's the position that they are generally taking. Nothing else. They don't care about, are your attendees subject to travel bans or anything else? That's what they are focused on. And so right now it's been fairly easy in the current, like right now, July, 16th, 2020, right now it is illegal to have a meeting of, say, over 50 people in almost any state or city in the country. Not all, but most. But the question is, but what about in October, November, or in your case, in your example, February? Are those bans still going to be in place, right? No one has a crystal ball. The further you go out, the harder it is to say whether that ban is still going to be in place. Most states and cities have these reopening plans with different phases. In most cases, the large gatherings like association conferences are not going to be to the final phase. Some states and cities have laid out the criteria for when that will happen. Usually they say when there's a widely available and widely administered vaccine, that's effective. And so, but some don't have any criteria whatsoever. So it's really difficult to say when you get to that point. So as you can imagine, that force majeure clause, if you're successful in effectuating a force majeure termination, then it enables you to get out of the contract without paying any cancellation penalties. That's why it's so significant. And if you have say we're mid-July right now, you got a meeting in mid-August or even mid-September or late September, and you pull the trigger on a force majeure termination right now, almost anywhere. It does matter what city or state you're in, because as we've seen, some state and local governments are being more stricter, more conservative than others in terms of the reopenings. That factors into it as well. But almost anywhere, you're 30, 60 days out, you're going to be in really good shape in pulling the trigger and successfully exercising a force majeure termination. But as you get further out, like February, that's where it gets a lot more difficult. So all of the different factors that go into this analysis, the most important factor is the timing. Timing is the most critical. The language of your force majeure clause matters. The nature of the state and local governmental restrictions matter. Maybe the ability of your attendees to attend based on employer-imposed travel bans might be relevant, but the most relevant factor is timing. And this is why, of all the different advice that we give to our clients on this, the advice they hate the most, but that I really hold firm on, and it's worked in so many cases sometimes, is wait. Don't pull the trigger on cancellation. I know you're under great pressure from your attendees to pull the trigger on force majeure termination. Everyone's apprehensive. This virus, it affects people in different ways, but seeing this across the board for lots of different reasons, not just fear, health and safety based, but economic reasons and other reasons. There's enormous pressure on most associations to pull the trigger and cancel that in-person meeting and decide to make it virtual or not have it at all. And sometimes it can be very difficult to wait until you get to the 60-day mark, 60 days out. my basic advice has been the earliest I like to see any force majeure termination. And when I say termination, I mean the written cancellation notice being provided to the property, because it generally has to be in writing. And the form of that notice, by the way, is very important. You definitely want to have your attorney involved. It has to be a really strong termination notice that clearly spells out all the reasons why you're entitled to force majeure termination. But I generally don't like that notice to be sent any sooner than 90 days from the start date of the meeting. Really important to wait till at least the 90-day mark. The longer you can wait, this is what we're seeing, the higher the odds go up of your success that the hotel or whatever will agree to the force majeure termination. But at least you got to wait until 90 days out. So for, say it was beginning of February, then you're looking at beginning of November. And I know that's a long ways off. You also run the risk, so to speak, I hate to call it a risk, though, that, we all want this virus to go away and the situation to get better. But there is that risk from your association's economic perspective that if you're in a particular state that, say, is more aggressive on its reopening plans, that there might not be, a ban in place come early November. But frankly, if you want to go the force majeure termination route, I don't think you have much choice, because what will happen almost without question, I can almost guarantee this, is that the hotel will say, sorry, we're not accepting it. It's too soon for you to do that. You have no way of knowing what's going to be in place prior to then. So if you can't, just say you can't wait. Your members are saying, your board's saying, I just can't wait any longer. We can't wait till early November to pull the trigger on this. What's your option? Really the only other option, of course you have an option to still go ahead with an in-person meeting, but really the only other option is to negotiate with the property, to negotiate with the hotel, kind of the tried and true method of avoiding cancellation penalties, which I've been doing for 25 years with clients, is to book another meeting in the future and try to get them with that same property and get them to waive the cancellation penalties in exchange for you booking the future meeting. Like you're canceling 2021 February, but you're going to book 2023 instead. And hopefully they agree to either waive all cancellation penalties or at least waive some of them or most of them. And the way they usually do it is, usually the negotiations will go like this. You tell them that we can't, our members just aren't going to come. We can't hold this meeting. We're going to have to cancel the in-person part, but we want to work with you. We like your property. We want to, rebook. Our next open year is 2023. We'll sign a similar contract, similar number of people. But you got to agree to waive our cancellation penalties. They come back and they say, we like you. We want to, encourage your business. You're a good client, customer, whatever, but we'll agree to waive. We're going to assess the full amount of cancellation penalties. We'll apply 50% of it toward your future contract. Basically, the amount that 50% of it will be credited toward monies you pay under that future contract, but the other 50% we're going to charge you. That's usually where the negotiations start. And then you got to go back and forth and try to get them down to as close to zero as possible. And the other thing that I strongly try to recommend is that the hotels are really big on cash right now because they're cash strapped. So they're pushing hard for deposits. Like even if they agree to waive all the cancellation penalties, they're in a lot of cases they're pushing hard for you to make big deposits for the future meeting. I try to get my clients to push back hard on that, because what we're finding is that the leverage in these cancellation negotiations, even in force majeure and whether the hotel accepts it, a lot of it has to do with what sort of deposit money do they have. If they have a lot of your deposit money, they're more likely to say, sorry, we don't accept force majeure. We're going to keep your deposit and apply it toward the cancellation fees that you owe us. And whereas if they have no deposit money, you have a lot more leverage there. So really try to push hard to not have to pay big deposits up front. All right, I'll stop there.
No, that was great. And you actually covered, I think, most of another question that we have. But I'm going to say it again, just in case you have any other thoughts or comments on it. So this question is, if attempting to enforce your force majeure clause prior to 90 days, which you don't recommend, how successful would the reasoning of institution travel bans likely be, assuming majority of associations have travel bans in place during the time of your meeting?
Unfortunately, it hasn't proven to be very helpful. The hotel's attorneys and the convention center's attorneys, they don't put much stock in that. Sure. They basically say it's not our fault. I respectfully disagree. Um, you know, part of it depends, and this is why this is so complicated. Part of it depends on the language in your force majeure clause. So let me qualify what I just said. What I just said is the case if the language says impossible or illegal. If it also says commercially impractical, or sometimes it says commercially impracticable, same thing, then I think you have a stronger argument that an institutional travel bans that prevent your members from attending is relevant to the analysis. But if it's just impossible or illegal, it's a much harder sell. It's a bigger leap to get there and make that argument. Um, and then the other factor is timing, right? Now, granted, there have been so many employers that have said we're banning all travel through the end of the year, for instance. Some that have even said through the first half of next year. Some of it's health and safety related. A lot of it's economic related. And, but the hotel also might push back and say, okay, we know you have a travel ban and a lot of your, say you have commercially impractical in your force majeure clause. And this is for that meeting, a hypothetical meeting or real meeting in February. And, they come back and say, well, how do you know that these travel bans are going to be in place come February? We're just not going to put a lot of stock in that. So again, the timing is critical. All comes back to timing. The closer you can get, the better. And if you are going to rely on that, if you do have the commercially impractical language, and you want to use this as one of the arguments in your force majeure termination notice, that is a case where I do recommend doing some sort of a survey of your members, some kind of survey polling to try to get data to support those arguments. And one thing I've noticed, because I've been asking clients to run that stuff by us, because I've seen some of these surveys after the fact, I'm like, oh God, like the questions weren't the right questions, or they weren't written in the right way to be really helpful in the legal argument. So I've been asking them to run the questions by us in advance, and thank goodness, because we're making changes to almost every one of them. You want to ask the right questions, right, to be able to support the arguments.
Sure, that makes a lot of sense. And then this might be a little too vague, but let me know your thoughts on this one. What do you do if a venue just ignores your attempts to cancel? That's all the question says, so I don't know about force majeure. I don't know anything else.
I think what it implies is that the association did a force majeure termination, and it's crickets from the hotel. It happens. It happens a lot, believe it or not. It probably happens in 50% of the cases that we've done force majeure terminations. Frustrating as hell. Everyone wants closure, right? You're waiting for the hotel to say, yeah, we agree, you're off the hook. I have one, I think I'm talking to them tomorrow. It's a huge conference. I won't say where, but the hotel, they did get back to us. This is not this question, but they got back to our client and they said, we received your force majeure termination notice, and you owe us $1.4 million in cancellation penalties. And then it goes on to say, that being said, we'd like to talk to you about, rebooking for, I think the next open year is 2026 or something like that. And if we can rebook, then we'll talk about it, basically opening the door to negotiations. But they're, protecting themselves in that regard. And I do expect we'll be able to negotiate something, but it's really a big concern because this will put the association out of business if they had to pay that. But in so many cases, you hear nothing. And that's okay. Put it this way. I'd rather you hear nothing than you get the bill for the cancellation penalties. And what tends to happen is if you're going to get a bill for cancellation penalties, they usually tend to do it within 30 days of your notice, maybe 60 at the most. There is a lot of backlog because there's so many furloughs in the hotel industry right now, including legal counsel, who always has to review this stuff. But, no news is good news. It's frustrating, but it is what it is. But you have to take the position that once you terminate, it's terminated. You can then let your members know. Never let your members know you're going to cancel before you actually cancel. Really important advice. We've had some clients who did not follow that advice and got burned by it. The hotel basically saying, look, you already made a decision to go ahead and cancel, so here's your cancellation bill for penalties. It's really important. Now, inside the tent, so to speak, talking to your board or whatnot, you can have confidential discussions, remind people of their confidentiality obligations. Like if you have a meeting in October, what are we, July? August, September, October. So say you have a meeting in late October and you're following the advice to wait until 90 days out, which is the end of July. Your board has already made a decision. You're going to cancel, but you do not want to communicate that to anyone. Now, I had the question, do we need to do all the usual marketing and everything else that we're going to do? No, you don't. You might have, if there are certain things in the contract with the hotel that you're obligated to do, like agreeing on room setup or menus or things like that, by certain dates, you got to follow those things. It is really important so that you can't be held to have breached the agreement. But you can drag your feet on opening registration. You can not send out any marketing you might typically do. If you know you're going to have a virtual meeting instead of an in-person meeting, one thing that we've been encouraging our clients to do is to say, and I got this idea from one of my clients a couple months ago, and I've had others now who have done it really successfully. And they basically said, we are having the meeting one way or another. We don't know if it's going to be in person, virtual, or a combination, but we're going to have it one way or another. So go ahead and register, and we'll figure out the registration fees, once we know what's going on. And here's a lineup of our speakers. And basically, we're going to have it one way or another. That is one way. It doesn't work for everyone, but it might be a way to help be able to move forward with getting people excited and interested, registering, get it on the calendar, even though you really know it's going to be a virtual.
Awesome. And then I would say this is probably the last question. Do you have a reliable, good resource to check the actual number of people allowed by state/county, etc., for meetings?
No, there is none. I did see something that I think it was the New York Times put out, but it was more focused on some of the other restrictions coming from state and local governments, not focused on the large gatherings. Trust me, my colleague and I, she's the one that usually does most of this. And I don't know exactly what she does, but telling you Google is the best research tool for this stuff. And it's actually not very hard from what she tells me. Because she researches it every single time we do a contract analysis. And then oftentimes, like this yesterday, I saw one that she updated because we had given guidance from 6 weeks ago. And of course, now things change all of the time. You got to keep doing that research on a regular basis. Things change on a daily basis. And you have to look at both the state and the city or county, because sometimes the city or county has greater restrictions than what the state has. Sometimes the state is greater than what the city has. Sometimes they're in conflict. You probably heard about like this ongoing battle between the governor of Georgia and the mayor of Atlanta. The governor, he wants to open things up faster. The mayor wants to take the opposite approach, and they're battling who has the right to do what. But bottom line is just Google it. It's generally not very hard. But what you really want to focus on are the bans on large gatherings and kind of these phased reopening plans, because the bans on large gatherings are generally part of that. You got to look at the number of people that are allowed. And for the number of people, what you're usually going by is if your contract with, say, a hotel provides that you're expecting X number of people, or sometimes usually it doesn't say the number of attendees, but it'll have the number of people estimated for, the meeting rooms or whatnot. That's generally the number you're going to go by in terms of the expected number of attendees. So anyway, unfortunately, there is no one source that anyone has put together. And frankly, if there was, you'd have to update it every single day. It would be a full-time job.
Sure. That makes a lot of sense. Well, is there anything you'd like to close up this session with before we close out?
Just one other thing. It's top of mind just because of the last call with a client I was on. And it may be a bit premature. No, it is a bit premature for most associations, but it's going to come here sooner rather than later. And some are already doing it. And that is office reopenings, right? And I think most associations, most nonprofits generally, we're fortunate to be in an industry where we can work remotely and still get the job done. That's not the same for a lot of professions and industries. But most associations have physical office space. They're paying rent, myself included, from my law firm, which we're not using. But there are a lot of benefits to getting back into the office. I've had a number of association CEOs tell me that while they're making it work, they don't feel like their employees are nearly as productive working from home as they are in the office. They're missing certain dynamics. Even with video calls and things, it's not the same, and they really are eager to get back to the office. And when that time comes, well, first off, in some states and cities, it's not even allowed to happen yet. In most, it's starting to happen, and in some, like in Virginia, I think I mentioned this earlier, they just came out yesterday with guidance on office reopenings. Maybe I didn't mention it. Office reopenings and mandated things that you have to do if you're going to reopen your office. These are the steps that you need to take, kind of similar to CDC guidance on large gatherings. This is mandatory guidance for office reopenings. OSHA, the Federal Occupational Safety and Health Administration, has put out very detailed guidance, actually 2 sets of guidance now, on office reopenings and what you should do to keep it safe. It's not mandatory, it's guidance, advisory guidance, but it's still very relevant. Again, for that same issue I talked about earlier, the standard of care. So this is going to the issue, the legal issue of if we reopen our office, what do we need to do to protect our association from being liable if one or more employees files a claim that they contracted the virus at our office? Same basic analysis as meetings, but it's a bit different because it's in the workplace. So you have OSHA guidance, which OSHA they only apply to workplace. It doesn't apply to meetings. And so, by the way, yeah, that Stay Safe Minnesota guidance is really helpful. I read through that after I did another webinar. Maybe it's for you guys, I think. Really great stuff that I think was a coalition that the government, kind of an advisory coalition that they put together, and working with government officials came up with that guidance, which is really helpful. But back in the office stuff, it's the same basic issue. What's the standard of care, and what do we, the association, have to do to avoid being held liable for negligence in allowing our employees to contract the virus at our workplaces? We're at the top of the hour, so I don't have time to get into it, but that is one of the articles that I wrote, very detailed. It links to the 2 different sets. I just updated it recently to link to the 2 sets of OSHA guidance that have been put out on this. There's also a discussion of liability waivers, kind of similar issue that we talked about. And then there's a discussion of workers' comp insurance. So workers' comp is the insurance policy that would step in if someone files a claim, an employee says, you were negligent in the office reopening and I contracted COVID as a result, and I'm therefore suing you. They would have to go through in most states and cities, have to go through the workers' comp process. That's kind of where they're forced into. In your workers' comp insurance, there is no COVID exclusion or communicable disease exclusion in workers' comp policies. So that is a very important policy, that there is some real protection there under those policies. But anyway, take a look at that article as you start to get into office reopenings. This is not easy stuff. It's expensive. It's not going to be an easy thing to do, but if you want to reopen your office, there's no substitute for taking these steps to help protect not only your employees, but your association.
Sure. Awesome. Well, thank you so much, Jeff, for taking the time to do this follow-up question and answer session with us. We really appreciate it. And we look forward to getting those articles from you to send out to the people who have attended today.
Great. My pleasure. Thanks, Sarah.
Thank you. Have a good day.
You too. Bye.
Bye.